The offence of burglary is set out in Section 9 of the Theft Act 1968. There are two offences of burglary created under Section 9. Burglary under Section 9, 1a, and burglary under Section 9, 1b. In many instances, the same conduct could amount to an offence under both sections, but not always. There is also an offence of aggravated burglary under Section 10 of the Theft Act 1968. The maximum sentence for burglary is 14 years imprisonment in the case of dwellings and 10 years for all other buildings. Aggravated burglary carries a maximum penalty of life imprisonment. A person commits burglary under Section 9, 1a, if they enter a building, or any part of a building, as a trespasser, with intent to either 1. Steal anything in the building, 2. Inflict GBH on any person in the building, or 3. Do unlawful damage. This section is thus concerned with entry with intent. For burglary under Section 9, 1a, there is no need to prove that the ulterior offence was actually committed. A person commits an offence of burglary under Section 9, 1b, if, having entered as a trespasser, he steals, attempts to steal anything in the building or attempts to inflict GBH on any person therein. The main difference of the two offences of burglary is that under Section 9, 1a, the intent must be formed at the time of entry, whereas under Section 9, 1b, the intent to commit the ulterior offence can come later. Also, Section 9, 1a, covers unlawful damage, whereas Section 9, 1b, does not. Section 9, 1a, does not require proof that the ulterior offence was committed, whereas Section 9, 1b, does. The elements which make up the actus reus of the offence of burglary are common to both subsections. These are 1. Entry. 2. As a trespasser. 3. A building or part of a building. Initially, it was held that to amount to an entry, the defendant had to make a substantial and effective entry. This was established in R.V. Collins, where it was unclear whether the defendant was inside or outside the window when he was invited in. However, later cases suggest that this is no longer required. In R.V. Brown, the defendant was liable for burglary when he smashed the window of a jeweler's and leaned in to take the jewelry. The court held that he was only required to make an effective entry. It need not be substantial. In R.V. Ryan, the defendant was found wedged in the kitchen window of the home belonging to an elderly man. His head and right arm were inside the property, but the rest of his body was outside. The fire brigade had to be called to remove him. He was liable for burglary despite the fact the entry was neither substantial nor effective. There is no statutory definition of building, although Section 9, 4, states that inhabited vehicles and vessels are included even if not inhabited at the time of the offence. This provision was examined in B&S v. Leithley, where a lorry container was considered a building. It had been resting on sleepers and was used as refrigeration storage. It was connected to the electricity supply and had been in the same place for 2 to 3 years. Conversely, in Norfolk Constabulary v. Seekings and Gould, 2 lorry containers used for storage did not amount to a building. They were still on wheels and not connected to electricity. Entering part of a building was considered in R.V. Walkington, where it was held that there was no requirement for physical separation. The defendant had gone behind a counter in Debenhams to look into the cash till. The defendant must enter the building or part of a building as a trespasser. This covers those who may have permission to be in the property but exceed the permission by doing something which they were not invited to do. In R.V. Jones and Smith, the 2 defendants went to the home of one of their parents and stole 2 television sets. The father gave evidence stating that his son had permission to be in his house. However, the court held he had exceeded his permission by stealing and he was a trespasser. According to R.V. Collins, the mens rea of burglary requires the defendant to know they are a trespasser or be reckless as to whether they are trespassing. In addition, the Section 9, 1a offence requires intention to commit one of the ulterior offences. For the Section 9, 1b offence, the requisite mens rea of the ulterior offence must be present. In summary, there are 2 offences of burglary created under Section 9. A person commits burglary under Section 9, 1a, if they enter a building, or any part of a building, as a trespasser, with intent to either steal, inflict GBH or do unlawful damage. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.